Welcome, listeners and viewers, to another episode on Rising Above Shadows of Abuse, Rasa. I'm your host, Graceovba. This is where we discuss topics relating to abuse, mental health, society, and culture. Today's episode, our next newsreel is from the Guardian newspapers by Shanti Das, dated the 8th of December 2024. The Crown Prosecution Service, CPS, does not know how many rape cases have collapsed after defense claims of sexsomnia, despite fears the rare medical condition is being exploited. The Prosecution Agency for England and Wales has previously pledged to robustly challenge sexsomnia claims after a string of high-profile cases where sexual offense suspects were acquitted or had their investigations dropped after the disorder was raised. Suspects charged with serial sexual violence and child abuse are among those who have claimed they were in a sleepwalk state at the time of the alleged offending, so could not be found guilty. Sleep experts say such claims can be difficult to disprove. In one high-profile case, the CPS apologized and paid damages for failing to properly challenge the defendant's claim that he had not raped a woman, and that instead he had been suffering from sexsomnia and engaged willingly while asleep. Now, a Freedom of Information request has revealed that despite its public promise to improve its handling of sexsomnia claims, the CPS does not know how many cases it has dropped in the past 5 years or refused to bring charges in after sexsomnia was raised. It also does not know how many times the defense has been used in court and how many times it was successful, saying it did not record or collate data on defendants or suspects' defenses. The CPS said all sexsomnia claims were robustly interrogated and suggested that collecting data on sexsomnia was not necessary because it undertook detailed reviews of individual cases to identify learning opportunities. But Jade McCrossan-Nethercott, 32, who took legal action against the CPS after it dropped her rape case in 2020, said the lack of data collection was absurd. If no records are kept, how can they identify patterns, track the misuse of this defense, or access whether reforms are actually working, she asked. Unusually in her case, the defendant's legal team claimed that she, rather than her alleged attacker, had been suffering sexsomnia at the time of an alleged offense. The CPS later sent her a lessons learned letter, promising it had taken steps to prevent mistakes in future. But McCrossan-Nethercott said the lack of data collection significantly undermined the pledge. Victims deserve more than well-meaning assurances. Without data, the CPS is essentially operating blindly, she said. Sexsomnia is a recognized psychiatric disorder that can cause sufferers to engage in sexual activity while in non-REM sleep. They may have their eyes open, but no awareness or memory of their behavior. If a jury accepts a defendant's claim that a person was in a state of automatism, such as sexsomnia, at the time of an alleged offense, they will be found not guilty. Lab tests and partner histories can be used to try to establish whether a sexsomnia claim is genuine, but it is difficult to completely disprove. Many of those successfully pleading sexsomnia in court have not known history of sleepwalking and no formal diagnosis. Campaigners are calling for lab tests, bed partner interviews, and medical history to obtain as a minimum in all cases where the condition is raised. In April, an observer investigation identified 80 cases over the past 30 years where defendants accused of rape, sexual assault, or child sexual abuse claimed to have been sleepwalking or suffering from sexsomnia at the time, including 51 in the past decade and 8 in the last year. The figures are likely a significant underestimate, as many cases do not reach the public domain. It also found evidence of law firms advertising the so-called sexsomnia defense and boasting of charges being dropped after it put pressure on the CPS behind the scenes. The findings prompted a warning by Dr. Neil Stanley, a sleep expert who has acted as a witness, that the defense was in some cases being used cynically. I know in my heart of hearts There are cases where guilty men have got away with it, he said. The CPS said it robustly challenged all Sexsomnia claims and pointed to 3 recent cases where it secured convictions. Christopher Johnson, 40, was convicted in June of 16 sexual offenses after a jury rejected his defense. In September, Connor Chambers, 31, was convicted of 19 sexual offenses, including 11 counts of rape, after claiming to have sexsomnia. He was found guilty and jailed for 30 years. Plus 6 on license. Another man was jailed for 10 years in March for assaulting 2 university students. A spokesperson said that in court, any defense of non-insane automatism is robustly interrogated in exactly the same way as any other defense. He added that the CPS had introduced safeguards in sexsomnia cases, including referring decisions to drop cases to senior officials for approval. But when asked how many such referrals have been made, it said it did not know and that it would take too long to manually review. Victim support called for the CPS to reform its approach. Michaela Claire Addison, National Sexual Violence Lead at the charity, warned that it will become the new rough sex defense, a colloquial term for defense claims that victims consented to being seriously hurt and sometimes killed during rough sex that went wrong, as well as tracking the prevalent and outcome of cases where sexsomnia was raised. She said the CPS should monitor whether it arose before or after the defense firm became involved. She added, it is vital that the CPS collects data on sexsomnia cases so it can identify and tackle its growing trend. Listeners and viewers, what do you think about this? Can you leave your views as relates to this via email address risingaboveshadowsofabuse@gmail.com. Thank you.